We're going to start this unit by talking about the core differences between criminal and civil law, and particular attention is going to be paid to who the actor is who brings the case, what the penalties are that are available, and what the burden of proof is in criminal versus civil cases. So let's start with criminal cases. So here, the government is the actor who brings the case. This is a government acting on behalf of the society against an individual because a criminal law is suspected to have been breached. And if a person is found guilty, they could be fined, but they can also be imprisoned. They can actually lose their liberty and be imprisoned possibly for life. They could even lose their life in areas where the death penalty might apply. So very, very strong penalties that really go to core constitutionally protected rights. And so as a result, we want to make sure that the government can prove their case beyond a reasonable doubt. So that's we don't know exactly how big an area that is, but it's way beyond 50%. It's up in the 75%, 80%, 85% surety area, where we want to make absolutely sure beyond a reasonable doubt that this person committed a crime, and if they have, only then can we deny them their life and their liberty or their property through fines and so forth. And so that's the basic scenario for criminal law. For civil law, it's quite different. Civil law involves lawsuits between two parties. Now, sometimes the party could include the government. So, for example, you could imagine a corporation might sue the federal government because the federal government has imposed a regulation that the corporation thinks is inappropriate. Or we talked earlier about the takings clause. So I mentioned a hotel that might be upset that the regulation of swimming in the water was hurting its business. If it wanted to make a claim under the takings clause, it would file a civil suit against the government. So the government can be a party in a civil suit, but it's very different. It's not a criminal case brought by the government in order to enforce a criminal statute and potentially impose criminal penalties. Instead, it is a suit that is looking for either monetary damages or what's known as specific performance. And we'll talk about specific performance in the contract unit. But the idea is sometimes you want the other party to do or not do something. Money won't do it. So for example, if you were trying to protect an historic building from being knocked down, you as a member of the Historic Preservation Commission might file a lawsuit asking a court to prevent the building owner from knocking down the historic building, something like that. Monetary damages wouldn't solve that problem. So we could have monetary damages, we could have specific performance, but no criminal penalties. Nobody's going to be put in prison in a civil case. And as a result, the burden of proof is lower. It's proof by a preponderance of the evidence. Preponderance of the evidence is really 51%, more likely than not. And so if a jury finds something that is more likely than not to have occurred, that the plaintiff has proven their case, then the plaintiff can win that particular lawsuit. Little bit of nomenclature here. Plaintiff and defendant is the way we refer to the parties in a civil suit. The plaintiff is the one who's bringing the claim and has to get over that burden of proof, that preponderance of the evidence. The defendant is the one defending it. In a criminal suit, we're talking usually about the government, either the state government or the federal government, against a defendant. And again, there you'd have to have proof beyond a reasonable doubt. So that's the distinction between criminal cases and civil cases.